An Oregon transfer on death deed is a tool that allows a person to transfer their ownership of real property to a designated beneficiary upon their death, also known as a beneficiary deed or a TOD deed for short. It's commonly used to avoid the lengthy probate process, which can be drawn out and costly. In this video, we'll cover how a transfer on death deed works, legal requirements, and how to revoke it if necessary. We're eForms, the world's largest online database of fillable legal forms, and we're here to simplify everyday legal processes so that you can take matters into your own hands. To create your own transfer on death deed, click the link at the end of this video. Let's start with the basics. What is a transfer on death deed and how does it work? Typically, when a person passes away, their properties and assets go through the probate court before they can be dispersed to the rightful heirs. It can be a very long and complicated process. A transfer on death deed, also sometimes known as a beneficiary deed, is a type of deed that allows a person to bypass probate and transfer the ownership of their real property to a designated beneficiary when they die. The transfer becomes effective after the beneficiary records a notarized affidavit confirming the grantor's death. So what are the legal requirements for a transfer on death deed in Oregon? The deed must be recorded with the county recorder's office in the county where the property is located prior to the grantor's death. The deed must be signed by the grantor in the presence of a notary public. A legal description of the property must be included in the form. This can be found on the property deed or at the county recorder's office. Keep in mind, it's not required by law in Oregon for the grantor to notify the beneficiary about the transfer on death deed or for the beneficiary to accept. Finally, can a transfer on death deed be revoked or changed after it's already been recorded with the county recorder? The answer is yes. In Oregon, a recorded transfer on death deed can be revoked or changed using one of three methods. Recording a transfer on death deed that revokes the deed or part of the deed expressly or by inconsistency. Recording an instrument of revocation that expressly revokes the deed or part of the deed. Recording an inter vivos deed that transfers an interest in property while the transferor is still alive. For the revocation to take effect, it must be recorded before the transferor's death in the deed records of the county in which the property is located. Ready to create your own transfer on death deed? Click the link below to get started using our easy-to-use fillable form. And don't forget to subscribe to our channel for more videos that simplify complicated legal matters.